With so many people moving here to Tennessee from all over the country, today I wanted to do a video that sort of touched on what the legal aspects of real estate are here in Tennessee. The laws are different in every state, and I thought the best way to do that was to sit down with our in-house attorney, Griffin Dunham. Griffin is one of the owners of our sister title company, Momentum Title. He owns 3 different title companies. He's been an attorney for 22 years, and he's argued in front of the Supreme Court and won, right? Yes.
It's been a while, but yes.
It's been a while, but still, this is a guy to know. This is a guy we all go to here. And so welcome, Griffin. Thank you for doing this with me.
Appreciate you having me. Thank you.
Yeah. Okay, so we're going to get to my first question, guys. What state requirements need to be met to be able to sell a loved one's home after their passing? We discussed this a little bit. You said there was like a certificate.
Yeah, so I'll give you the lawyer answer. It depends. It depends on whether or not that person left a will or not. Okay. Really is what it comes down to.
So yeah, that was my next question, if they don't have a will.
Yeah, so think of property descends. So once you pass away, and property oftentimes isn't part of probate. So people oftentimes think, oh, I have to probate an estate. You don't have to. A lot of times you don't have to. Sometimes it makes sense. Sometimes it's required. But bottom line is you don't always have to go through probate. In Tennessee, let's talk about intestate, meaning without a will. If someone dies without a will, you go down and then you go up and then you go side to side. So if someone were to pass, you first look to, do they have one, are they married? In Tennessee, if they're married and one passes, well, the real estate automatically goes to the other one. Why? Because of tenancy by the entirety. We just talked about. And same thing if you have a right of survivorship, which is what the entirety of properties does. So in that situation, if there's a spouse, it automatically vests in the spouse right away. If there is no spouse, then you go look to children. Or if there is a predeceased child, their grandchildren. Because then they all take, if you have 3 kids, you go with 33%, 33%, 33% is who would be the separate owners of the property. And if 2 of them are still alive, one of them has passed, but then there are 2 owners or 2 grandchildren, then you have 33, 33, and then those other 2 would 16.5% split that deceased child's ownership interest that passed along to them through a doctrine called per stirpes. But you, in the intestate world, you look to children. If there are no children, then you go up to parents. If there are no parents who are alive, so if there are no children, there's no spouse, no children, no grandchildren, then you start going side by side. Then you start going to, are there siblings? Are there, and then you go to cousins.
Really?
And so,
okay.
Or aunts, uncles, cousins. So there's a long chart. Fortunately, you rarely ever get that far. Right?
Okay.
You don't ever get that far, but that's going to determine who owns the property. If someone dies intestate, then the property is going to descend somewhere. So it would descend down and then it would have to go up. So you know who the owner is going to be. There are some rules in Tennessee. You can't sell property within 60 days after someone has passed away. From a title perspective, you're not going to be able to convey insurable title for bare minimum 6 months after they pass, or within 4 months after, if there's a probate case open 4 months after notice has been given to creditors. Those are in the weed timeline issues that probably aren't, this isn't the best place for them. But just know that from an ownership standpoint, if there is no will, then it's going to go to spouse first, children second, third, parents, fourth is when you'd have siblings.
So what if the parent, like, say, what do you have? So I had some other neighbors. I walk a lot, so I talk to all my neighbors. So these guys had lost their mom. Neither lived in this state. They were there cleaning the house out, and they had learned that they couldn't just turn around and sell her house, that they had to get this certificate from the state, and it was a waiting period of like 30 or 60 days.
So in order to sell in that situation, you'd have to have the death certificate. That doesn't take 60 days, though.
This was something that came from the state. That because they were kind of frustrated because they were like, we want to sell now. We don't want to sell during the holidays, but we have to wait for this certificate or something to come
So
through.
10 Care will have to get involved to provide a release saying that the estate doesn't owe us any money. We didn't take care of the person.
Okay.
But there would have to be a death certificate. Sometimes that can be a holdup. If they don't know the cause of death and they hold it open, sometimes we don't have a death certificate right away because there's an investigation. After that, though, there's nothing else that can prevent it. Now, there would have to be 2 affidavits of heirship. Those are common, and in that situation, the affidavit would be from at least one disinterested person, not a beneficiary of any estate asset, and they would say, "I know the decedent. I knew her. I knew she was unmarried at the time. I knew that she had 2 children, Jack and Jill, and I know that I'm familiar with their family history." So if you get 2 of those, then you record those affidavits along with other closing documents, and then that's what you use to show that you have a decedent who had 2 heirs, and that's what gets title companies comfortable that those 2 heirs are the proper owners who can sign the contract and you can ultimately close.
Got it. All right.
And of course, if there's a will, then you just look to the will to see where the property is going. But if there's no will, that's the process.
Got it. All righty. So it is a municipal lien search for open permits included in a basic title policy.
Not for open permits, no. So what is, though, is title companies don't guarantee the use of property. How you use it, because we don't know how you're going to use the property. But what we do is provide anything that has been recorded as a matter of public record. There's a repository, the Register of Deeds. That is where you go to record documents, and if it shows up with the Register of Deeds, it's going to show up in a title search, and it's then either going to show up on the commitment as a requirement, or it's going to be accepted depending upon what it is. But that's a different division. The existence of permits, the permitting process, what's open, what's approved, what's closed, does not go through the Register of Deeds. Therefore, it would not come up on a title search, and therefore it would not be covered on a policy.
Okay. All right. We'll do another how to check for permits video because we don't want to get too far into the weeds on that one. But
one thing that is interesting and what I think is a must is, let's say you're a buyer's agent and they want to look at a property in a subdivision subject to an HOA. Well, there are declarations, conditions, covenants, and restrictions that 100% have been filed. Nothing is an absolute. 99% of the time have been filed, have been recorded with the Register of Deeds. In those covenants, those restrictions, those are going to dictate how the property is used. It might say no pink houses. It might say you can't have a chain link fence. It might say you can't have a fence over 6 feet tall. No RVs or boats parked in the driveway. HOAs, subdivisions, they get to determine from an aesthetic purpose and from a sense of community standpoint how they want the property to be used by those who purchase the property. Those are matters of public record. So when a buyer goes to purchase the property, they don't know to go look at the Register of Deeds as to what is going to be allowed if they live in a certain area. And so I think, and those are not covered by a title policy. So if you're a boat enthusiast and you have 3 boats and you're buying a property, and then you later learn after you purchase the property by a cease and desist letter from the HOA that you can't park your boats on the driveway, you might be pretty upset. You contact the title company, you say, I can't use this property. And we would say, look at your title policy. We don't cover uses, we cover title. Okay. You got good, clear, marketable title. Their second call is to the buyer's agent.
Yeah.
So you knew that I had boats. Why didn't you tell me that I couldn't use this property for that purpose? All you had to do was get a copy of the DCCRs that were recorded. Mm-hmm. So in that situation, if you're moving into a subdivision, if you have buyers looking at it, you can get these through the Register of Deeds. You can contact the HOA. There are a number of ways that agents can get these. And if they don't, I know you do it, but there are a lot of agents who do not, and that ends up becoming a problem. So I think that people on their own should do it. And if they can't help, We're here to help. You're here to help. There are things that agents can do that you do that really helps clients in ways that they might not even realize it because you've already protected them before something even became a problem to begin with.
Yeah. Yeah. Great point. Okay, so when is an extended title policy recommended? I know back in the days of bank owns, when we were having, in 09, 10, 11, 12, we were seeing a lot of bank owns. Is that really the only time, or?
No, there's a standard policy that most people get, and then there are enhanced policies. And so really the enhanced policy does a lot more for 20% more than what the cost of a standard policy is. I always say to agents and to potential buyers, do not buy an enhanced policy until you've spoken with us first. You can commit to an enhanced policy the day before closing. So given that fact, let's look at your search first. Let's determine what the search looks like. Let's determine what the title history looks like. Let's see what is really where this property is situated. Because if you're in a subdivision where it's nicely platted and you have a certain lot number, the need for an enhanced policy would be a lot different than if you have a chopped up property that has different zonings involved, different neighbors with different easements running through it, and surveys that may or may not conflict with other surveys that have been recorded. So I think in that situation, it's just best to say that an enhanced policy could be good, but it also could be a waste of money. Let's have a discussion about it. And unlike you go to buy a car, they're always going to want to upsell you on the warranty coverage. It's not what we do. We don't sell an enhanced policy just because it gets us more money. We only do it if it truly is going to be beneficial. If it's not, I would say 90% of the time we tell people, I don't think you need it.
Okay, good. So are there common differences or surprises you see for people moving in from out of state? Since we get so many people from California, Florida.
Yeah, besides politics, I presume the taxes are the biggest concern that I see. I see people, and of course you never know where they're coming from, but people from California are paying more in taxes in 1 month than a lot of people pay all year, depending upon where they come from. So at the closing table, what we hear the most about is, can't believe you can get so much land so close to a decent sized city like Nashville. Two, they're always surprised about property taxes
being so much lower.
Okay. And then three, they're always talking about their politics. Wherever they came from, they moved away because they wanted to get away from that, and they're coming to Tennessee because of what they perceive to be a better political climate.
Got it. Okay.
Yeah.
So what are the most common potentially dangerous contract mistakes you see? And then to piggyback on that, what are the most common reasons parties end up in mediation or ultimately litigation?
Those are tough ones. So the contract mistakes that I see, there's a portion of every contract that allows for special stipulations, as you know.
Where we're not supposed to write legal language as agents.
Right.
Yeah.
And I know you love contracts. Yeah. You love the details. You love clarity. Well, some agents just want to get the contract signed. And we get the special stipulations, and we can already see that there could be a problem because it's ambiguous. The parties might be interpreting something differently. So I think that the first thing that comes, the most common reason that people get into a dispute is because of the interpretation of a special stipulation that has been drafted by the agents or the parties that just ultimately isn't clear. They think it's clear. Both parties think that they know what it means, but in reality, they have different interpretations, and then that comes out at closing. Whether it's a seller concession, is that inclusive of commissions? Is that seller concession inclusive of closing cost? Is it inclusive of title, or is it not? And the ambiguity of the contracts is by far number one. That's what the biggest problem is with contracts, is ambiguity. If a Contract is plain and unambiguous on its face, then no party is ever going to look outside the four corners of the document. You just look at it. You don't care about what the intent of the parties was. You don't care about anything. All you care about is what's the plain interpretation of that. But if it's ambiguous, then you start getting to go back into what's called parallel evidence. Start to get into conversations, intent of the parties, and that's where both parties will have their own intent. Well, this is what I thought, and it's really just a mutual mistake, or it's a mistake on both parties for not getting the language cleaned up. There are no real examples. I would say that one is the first one that's most common. The second is post-closing people complaining about the condition of the property.
Oh.
They'll say, you didn't disclose that there was water intrusion. You didn't disclose that the floors, or that there was, you can just come up with anything that you want. Water is the biggest one. Foundation is another big one. Infestations are another big one that constitute a nuisance. So those are the top two. And then third is financing. People say that I wasn't able to get financing. Well, they're killing their own deal by telling their lender that not to approve them. And so we have to get into, well, did you procure?
So they want out of the contract, and instead, I've not been personally involved, but so they're trying to say, they don't want the contract anymore. So they basically lie and say that they can't get financing, and they want the lender to.
Right.
Is what you're talking about, right?
That's exactly right. Because they've gotten past their inspection period, and it's the only contingency that remains. They got the appraised, but then they'll do something. And sometimes they'll even self-inflict. They'll get a loan on a car.
And or screw up their financing.
Right.
So then they can't qualify.
Yep. And the seller says that financing has to be through no fault of yours. Mm-hmm. Well, you caused this fault. And so they fight. And then second part of the question, I believe, was,
what's the most common reason parties end up in mediation or in litigation?
I think it's inspections. There's no mediation requirement in the Tennessee Association of Realtors. That's not mandatory. It's optional. People can always decide to mediate. But I think that people try to resolve issues most of the time on not about you've breached the contract or you haven't. They have to try to negotiate repairs. And that's where your negotiation skills really come in, because you don't need a mediator. That's oftentimes unhelpful. You just need to skillfully be able to understand what the hydraulic nature of the relationship is between the parties. There's always going to be a push and a pull. And so what can your client give up that doesn't mean a lot to your client, but means a lot to the other side? And then hopefully just negotiate that repair addendum or repair amendment so that the parties can still close. That's the biggest reason for termination of contracts is inspection.
Okay.
I don't know the number. I'll just pull a number out and say 85% are inspection related causes for termination.
Wow. Yeah.
Mm-hmm.
Sounds about right.
I don't like it.
We have covered a lot today. You're done.
Thank you.
You don't have to answer any more questions. I so appreciate you being here and doing this. And thanks for watching, you guys. If you have any question, I don't know if you want to have them contact you directly, or
I think they can contact you. I think that then obviously you can loop me in as necessary. Okay. But I very much appreciate the opportunity and your time.
Yeah, no, it's great. All right. If you guys have any questions for me about real estate, or if you do want to get in touch with Griffin, my contact info will be below as usual. And thanks for watching, guys. See you on the next one.
Thank you.